Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information, don't forget about our blog, consumerfinancemonitor.com. We've hosted the blog since 2011, so there is a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. Please leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you obtain your podcasts. Also, please let us know if you have ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. Today's podcast episode is a repurposed webinar that we did on March 25th entitled Impact of the Election on the CFPB Part 4. This is part 2 of that webinar, where we will address solar litigation, mass arbitration, the emphasis on unfair practices, cryptocurrency, the National Bank Act preemption, and the Depository Institutions Deregulation and Monetary Control Act opt-out litigation in Colorado. In addition to our very special guest, Ira Rheingold from the National Association of Consumer Advocates, our speakers today from Ballard Spahr are Dan McKenna, Joseph Schuster, Tom Burke, Jenny Perkins, and Melanie Vartabedian. If you missed part 1 of our repurposed webinar, and you want to hear it, that is already online, and I urge you to listen to it so that you get the full picture of what we think private litigation is going to look like during 2025 and perhaps for the next several years. And in part 1, in addition to featuring Ira Rheingold of the National Association of Consumer Advocates, we had other Ballard Spahr speakers who talked about FCRA litigation, AI's impact on litigation, and retail bank litigation, and state enforcement in private litigation.
So the next topic then is a shift away from these sorts of issues, and we want to now focus on solar. Melanie Vartabedian is a partner in our Salt Lake City office, and she does a lot of solar litigation and solar compliance. Melanie, we know that space has also been very hot from a litigation perspective since the election. Can you tell us what trends you're seeing?
Yeah, thank you, Dan. So it should come as no surprise that the solar industry has been growing. In fact, 2024 was actually the largest single year of new capacity added to the grid by any energy technology over the past 2 decades, with California and Texas leading in new solar capacity. So it should also come as no surprise there's been increased litigation in this area. So I'd like to just set the table with what's been happening over the last couple of years, both at the CFPB, the AGs, and then what we're seeing with private consumer litigation. We represent solar lenders, solar lender platforms, and entities or trusts that are holders of the lending paper. So the Minnesota AG, almost exactly a year ago, sued 4 solar lending companies for deceiving consumers into taking out loans based on the company's false promises of low interest and disguised hidden fees on more than 5,000 solar panel purchases in Minnesota. The 4 defendants there were offering a point of sale financing options for solar system installers. The case is actually in Hennepin County, Minnesota. It was removed to federal court, but then found itself remanded back to the state court. This is an ongoing dispute. The defendants filed a motion to dismiss that's currently scheduled to be heard in a couple weeks here on April 15th. Basically, the defendants have argued that the AG's claims are preempted by the Truth in Lending Act, TILA, and that these dealer fees is what they're called, these alleged hidden fees. They're actually seller's points that are permitted by Reg Z. So as everybody probably knows, Reg Z defines seller points as any charges imposed by the creditor upon a non-creditor seller of property for providing credit to the buyer or providing credit on certain terms. And seller's points are excluded from the finance charge even when they are passed on to the buyer, for example, in the form of a higher sales price, right? So that's kind of the crux of the solar lenders' arguments here. And the state's claims are dressed up in various theories. The core claim is ultimately premised on the argument that defendants violated state law by failing to disclose the installer fees. This was an undisclosed fee, a junk fee, right? That's been an issue we've seen targeted quite a bit, these undisclosed fees. And so we're seeing that here in the solar industry. And the defendant's argument is essentially that the AG's theories are preempted by TILA, by federal law. So the AG's opposition to the motion to dismiss is due in actually just a couple of days on April 1st. So we're keeping an eye with what's happening there. In terms of other AG actions, the AGs, state AGs were already very active against the solar industry, mostly related to installer conduct, right? So not so much the solar lenders, but the installers. In 2022, there were 9 attorneys general listed on the slide there that sent a joint letter to 5 solar lenders asking that they suspend loan payments for consumers who had systems installed by a company called Pink Energy that's now a defunct solar installer. The allegation was that Pink induced customers into purchasing solar power systems through false representations regarding the system's capabilities and anticipated electric bill reduction. There were also allegations about tax credits. And just last year, the Connecticut AG also filed a complaint against installers, and that is ongoing. That very same month, in July 2024, the Center for Responsible Lending issued a report called The Shady Side of Solar System Financing, in which it compared solar financing products to those used by predatory subprime lenders in 2007 to target low-income and minority borrowers. Also raised the issue of dealer fees, which is the same thing we saw with the Minnesota AG. So the CFPB, now we know their future is in question. Talked about that a whole bunch already. But last summer, the CFPB issued a spotlight on solar financing, which identified 4 main consumer risks. So the hidden markups and fees in the form of the dealer fees that we've been talking about, misleading statements about federal tax credits, misrepresentations and omissions about voluntary prepayments, and misrepresentations about financial benefits. The allegation there being that installers are overpromising the value of the systems and the potential utility cost savings. But again, it was the state AGs who were first to address it and are likely carrying the ball here going forward. So where the rubber meets the road for us is the plaintiff's bar. So what's happening? Well, we are seeing references to the Minnesota AG action in demand letters that we're receiving. Some counsel have hundreds of cases against solar lenders, but most of this is happening in arbitration, right, pursuant to arbitration agreements in the agreements. So as far as what we're seeing, we're handling a lot of cases involving allegations relating to the dealer fees, tax credits, general allegations that the utility savings are not what the consumer expected. So it's following the same lines as what we're seeing with respect to what the CFPB noted and what the state AGs are alleging as well. In some instances, the plaintiff alleges that the salesperson for the installer is an agent of the lender. And so that can make it hard to overcome a early dispositive motion because some courts or arbitrators hold that there's a question of fact, right, regarding agency. If a case is filed in litigation, often we're moving to compel arbitration. Some of our cases, there have been allegations that the contract was forged by the installer. The contract wasn't presented. There wasn't a meeting of the minds. The customer wasn't given adequate time to review the contracts, which are often presented on iPads, or just oral representations are made that contradict what's actually in the written agreement. And so if you get stuck fighting a motion to compel, some courts allow limited discovery on formation in those instances. One thing I wanted to touch on was substantively, these cases often implicate the Federal Trade Commission's holder rule, which is when the entity against whom these allegations are made is the holder of the loan. And under the holder rule, the holder of the paper is only liable for the amount of the loan itself and nothing else. So no damages can be tacked onto that, like punitive, statutories, and namely attorney's fees and costs, right, that the plaintiff or the claimant incurs. The California Supreme Court, though, in a decision called Pulliam, held that a holder can be liable for the customer's attorney's fees where there's an independent basis, so another statute that allows for the recovery of those fees. So the holder rule can be helpful. It can be a cap on liability for lenders. It also allows a consumer to make the same claim against a holder that it could make against the installer, and can make the holder liable for the actions of the installer. Sometimes, like with Pink, we saw that that's a defunct entity. So that can make defending these matters on the merits challenging and makes it so that the holder is left holding the bag. Ha ha ha, the pun. I did intend that pun there. I wanted to see what Tom Burke had to say about this because he is also handling litigation for financing platforms and lenders and the different roles that those entities have in this litigation.
Sure. Thanks, Melanie. So just brief remarks here. The interesting thing to me when I was learning more about this space initially was the number of players in the ecosystem, so to speak. So consumer signs up for installation of a solar energy system on their roof. You might think that you have the installer and the consumer, and that's it. Well, most of these systems are financed at point of sale, sometimes through a platform that is not itself the lender or the installer. They're the business that provides the electronic framework that matches the seller and the consumer and the lender. So you have the installer, you have the platform, you have the lender, which is the bank that is actually making the loan, and then you often have the current holder of the loan, which has been securitized. And all of these players are often implicated when the consumer alleges years later that their system is not producing as much electricity as they were told that it would produce, or when a part fails, or when they contend that the terms of the loan were unconscionable, or whatever the case may be. And so we are representing clients really at every stage of that ecosystem. As you noted, many of the biggest solar installers are bankrupt, and I think a lot of that is for macroeconomic reasons relating to their funding structure, not because they all faced insurmountable numbers of tort claims. But in any event, you often have several defendants who are litigating, and as Melanie said, the installer and the person who was there on the porch or in the living room when that agreement was being discussed and negotiated and signed, that person's gone. And so you're left to put those pieces back together. Ira, I'm not sure if you have any comments in that space or things that you're seeing there.
There's so much I could say. I agree with a lot of the analysis that you guys put forward. I will say a couple of things, though. One is, I think, in terms of our membership of both legal services and private attorneys, there may not be an area where we're seeing more complaints than in the solar space. And as Alan noted, I am the chairperson of the Center for Responsible Lending, and I was involved in them doing that report. As somebody, again, who I said grew up in the 90s and 2000s litigating predatory loans and the broker relationship and the secondary liability for entities, I think that's exactly what we're seeing here. We're seeing lots of fraud taking place by solar contractors. I would argue that a lot of those folks who failed because they were engaged in lots of really bad practices, which I think a lot of entities were looking at them. I think as private attorneys, we're always, again, these are more complicated cases because there are lots of entities involved. And in fact, oftentimes the lender is both the party who is maybe, as was said, is holding the bag, is the entity that actually is still in existence. I think that a lot of what we're seeing is that there really is, for want of a better word, a conspiracy happening here, where the solar finance company are sending out really our people and just saying, hey, you get us a loan and we'll finance it. Not dissimilar to what we saw. I mean, it's sort of the modern day Tin Man, but it's the same thing we saw with mortgage brokers back in the day. Make those loans, we'll approve them. We're seeing a lot of people signing loans on a tablet, and the loans turned out to be very different than the loan they thought they were signing on. We're seeing a lot of forgery. And I think, again, if I was involved in solar lending, I'd be really careful about who you're doing business with and who you're financing and who you're directing to make those loans. Because from my view of the world, from my experience dealing with lenders sicking the mortgage brokers out on the universe and saying, get us whatever you want, we will finance it, and then we're just going to securitize it, and nobody has anything to worry about, I think it's a significant problem. And I think solar lenders will be held responsible for the activity that's being conducted in their name, in their financing, because they're directing a lot of it. At least that's my belief, that they are simply being very not careful or they're directing those transactions. And I think those are things that the plaintiff's bar is going to set out to prove, whether we do it in arbitration or whether we do it in court. But I think I would say that in the conversations I've had, individual conversations with a lot of legal services attorneys, but also private attorneys, that they are getting complaint after complaint about the work that was done, the terms of the loan, the benefits received. I mean, I can give you stories of people getting solar panels applied when their house is completely under shade. But I think it is the modern day Tin Man. It is the modern day predatory loan. It's the modern day home contractor scam. And because there's so much money out there, or there's just theoretically a lot of money out there, there's lots of really bad actors in this space. And if I was making a loan, if I was a financial institution and I was making a loan based on a contractor sale on point, I'd be very worried about my liability.
Well, another topic that we could spend a really long time talking about, and probably a webinar of its own. Melanie or Tom, any response to Ira before we move on to the next topic?
I'll simply note that obviously this is it's a big ecosystem. There have been a lot of players in it. It is an area where the Bureau has focused with its spotlight last fall. And, I think no question, we want to find and encourage these entities to operate to very high standards with their construction and installation and also with their lending. And we're seeing those cases play out, all over the place right now.
Thank you. Okay, so then let's jump to what I think is one of the most frustrating trends out there. Ira, you mentioned arbitration. And Alan is here, who is the godfather of arbitration, but I'm not going to invite Alan to speak on that because we don't have enough time to do it. But
I've debated about that way too many times in my life. So.
No doubt. The topic that I want to transition then to is mass arbitration. And I understand, and I think all of us will agree that there's real value to mass arbitration in the right context. And I'm as certain as I can be, Ira, that your position on some of this is going to be, but you guys drafted the arbitration clause, right? You want to be in arbitration. That's ultimately not what I want to talk about today. Oh, go ahead. I'm sorry.
Okay, because I was going to say that, but go ahead.
Well, I can undermine it a little bit by preempting it. So what I want to focus, though, Ira, on what I think is a pretty disturbing trend of consumer plaintiffs identifying a topic and rounding up hundreds or even thousands of claimants and then threatening to file mass arbitration unless they receive a pretty massive attorney's fees award or payment. Often those cases candidly have little merit, but the lack of merit doesn't do much to impact things. It's not the driving factor. The driving factor is just the enormous cost of filing just a response in arbitration. And forgive me, let me advance this. So I want to walk through this. In the interest of time, I will skip some of the things I wanted to talk about, but I do think there's some really interesting issues here that we should dive into. But I want to begin, if I can, Ira, by just rewarding the folks who were able to stay with us for longer than an hour and tell them that I want to offer some free legal advice here and say that the best defense to mass arbitration is a strong arbitration agreement that has very specific requirements. And I don't want to bury the lead. The absolute best chance for you to avoid being, forgive the word, but I think it's extortion in some instances in mass arbitration, is to have the following provisions in your arbitration agreement. You need a notice and cure provision, a provision that requires each potential claimant to raise his or her hand and informally inform the company before they commence an arbitration. I like that to require some engagement by the consumer themselves, whether that's a signature or some basic information. I would also encourage folks to bolster their small claims court language to specify that companies can ask that the AAA or JAMS or others send matters to small claims. Most arbitration agreements that we see have a small claims carve out. We like to add language that invite both parties to move cases from arbitration into small claims if applicable. And then also tightening up some of the fee payment language so it's less likely to entice counsel to commence a mass arbitration. Those are just 4 things that I would encourage folks to do to avoid what the issues are coming that we're about to talk about. There's a lot of other things. Happy to discuss it. Anyone of the Ballard team can discuss that with folks. But I want to transition then, if it's okay, to talk about what we're seeing. And here you see a slide that just talks about how mass arbitration works, and I'll break it down for you pretty simply. Plaintiffs' firms gobble up a ton of potential claimants. They gather, in our experience, very limited information about those folks. They turn around and send a letter to a business that says, I have 1,000 people, I'm going to file in the AAA, and you're going to owe $9 million in AAA fees, or you can pay us $7 million to make it all go away. And if you negotiate that down, maybe it's $2 million. So something that I find really fascinating is how do they find these people? How do they find these consumers? And how do we allow this to happen? Through a lot of research and through very interesting private equity litigation involving a plaintiff's firm who tried to pitch a private equity firm on investing in mass arbitration, we're able to answer a bunch of these questions. And like almost every question my 4 kids ask me, the answer is social media. And it is a wild, wild world out there. These firms who are gobbling these folks up are finding little areas, and they are leveraging the data available to them in social media to send direct marketing campaigns to consumers. For example, if you reference a certain account or a card, or you look at certain advertisements, you might start seeing some of these advertisements that are inviting people to click if they believe that they were charged an unlawful fee or if they believe that they had some certain experience. When you click on that, you get to this page. This page asks you a total of 8 questions. And if you answer those 8 questions and click sign up, you're now part of a mass of consumers that these law firms will use to leverage settlement. And anyone on the video who goes and looks at their own online sign-up procedures would know that this would never pass muster, right? You can't even reach out and market to these folks if you're a financial institution. But law firms are using this very limited information to sign these folks up as their consumers, and then going to businesses and saying, I have all of these folks. And, frankly, putting the ethical obligations aside, this is one of the reasons why we advocate for notice and cure provisions and wanting the signatures of the claimants, because we find as we dig in that very few people who sign up really have any idea what they're signing up for. They think they're getting information. They don't realize that they're engaging counsel. I'm sorry, I'll stop there, Ira, because I've talked for so long. Do you have any thoughts about this before we get into how AAA and JAMS?
I have to laugh a little bit when you talk about how consumers who signed up had no idea what they were getting. And that's the whole purpose of the contract that they signed initially with the firm. So I find that particularly amusing. And that's a debate we've had for many years in terms of, well, consumers really don't know what they're signing up for anyway. Now, I am not going to condone mean, that's not what the folks I work with do. That's not within our ethical guidelines, and we actually have guidelines in terms of proper behavior in terms of representing people in the class action. We actually have a whole class action guidelines that we promote in terms of the ethics practices. Now, I know this is not class actions. I think, again, plaintiffs need to be creative plaintiffs' attorneys need to be creative in cases when they're seeing things are happening over and over again and saying similar abuses over and over again. So one, I would argue in terms of, I feel like, it's almost like we're role reversal here. Well, there's a few bad apples doing stuff out there, but in fact, we can't throw the baby out with the bathwater. So I'm not going to go there. But I think mass arbitration will grow. And I think it's going to grow, again, because of the standing challenges that we've seen lately in terms of some of the litigation out there. So do I love mass arbitration always? No, but sometimes if that is the way we are going to get remedies for lots of people as opposed to small individual cases, it's the way people are going to turn it.
Dan, I think our regulator on Ira's contributions must have kicked in here.
Oh, there we go. I'm sorry. I lost connection there for a second. Thank you, Tom, for jumping in. But
I think it may have been on Ira's end.
Oh, that's unfortunate. Well, hopefully, Ira, you'll be able to join us back in just a moment. But I want to, I appreciate the comments that Ira made, and I appreciate the acknowledgement that he doesn't support these things, because I do think that creativity has its bounds. And to the extent we're talking about pursuing businesses that Ira and folks that he supports, they believe have exceeded those bounds, I do believe that we need to take steps to reduce and narrow the abuses of mass arbitration. Ira mentioned that it's going to grow. He's absolutely right. It's already growing. We have a number of relationships at the AAA and JAMS who talk about what's happening. I post here some of their rules with respect to fees. I want to highlight just a few things in the remaining minutes that we've got. The first is there are new rules in the AAA that will allow you to only pay that upfront business fee of $8,125 and then get a process arbitrator who can help adjudicate whether or not that claim or group of claims should stay in arbitration or should move to another jurisdiction. We also list here a bunch of cases that I would encourage folks to look at, but they talk about different challenges to arbitration, challenges to state laws about payments for arbitration, and a host of other things that folks have attempted to do to avoid the mass arbitration vehicle. Here's my suggestion to you. If you find yourself in a mass arbitration that doesn't really belong in mass arbitration because the plaintiffs are not supportive of Ira or his ethical guidelines, but have chosen another path, raise your hand. Talk to the AAA, talk to JAMS. We have had a great deal of success going to them and saying, yes, we want to arbitrate cases. Yes, we want to arbitrate on a mass basis when it's appropriate. This isn't it. It isn't it because this claim is improper for a variety of reasons. The way they've signed up their consumers is improper for a variety of reasons. And engage in that dialogue with the AAA and JAMS. And I think you will find that they are receptive to talking about whether or not the matter should stay in AAA or JAMS. And if not, or if you lose that discussion for whatever reason, there are legal challenges that certainly are available, and they're listed here as well. Ira, I am certain that we could probably spend another hour on this, but we do have two other topics to try to quickly cover, if that's okay, and you're back. Are you back?
I am back.
Oh, good. Well, I apologize that we lost you there for a moment. I assure you that was not intentional on our side.
I was wondering after what I was saying that you did want to try to cut me off, but that's okay.
No, not at all. Not at all. And
we all experience technical difficulties with all the platforms we use. God knows.
No doubt. No doubt at all. So with that, I will transition back. And I know we've got a couple of questions that we might need to answer as a follow-up. But with that, I'm going to transition back to you, Ira, to talk briefly about unfairness. I know you've already spoken about that a little bit. I know you wanted to mention crypto as well, although you've addressed that too. And then we need to kick it back to Joseph to talk about the NBA preemption. So I'll defer to you, Ira, how you want to handle that.
Sure, I'll just be really quick. I just think that the things that we are looking at right now is the unfairness in consumer protection statutes. We think that that is a real interesting area for potential litigation. We look at behavior sort of in the sense we're looking at financial institution, corporate behavior, and through the lens of unfairness. And I expect more cases will be brought under those theories. And I think the same thing with fees, right? I think it's not quite statutory unconscionability. It's simply unfair. And I think the CFPB was heading in that direction and beginning. I mean, you saw that. I just want to touch on that because I think that's absolutely happening. I think the crypto space is a fascinating space. I won't talk about it much except to say that to this day, I've yet to find what the real use of crypto is.
Dan, I think Ira is still cutting in and out here for everyone.
Yeah, I'm sorry to hear that. So why don't we then go over to Joseph. Joseph, if you don't mind rounding us out here to talk about MBA preemption, we'd greatly appreciate it.
Mine, Dan, absolutely not. No, I was getting concerned on time. And I wanted to touch on a couple of things that were said earlier in the presentation. Ira was saying, and Ira, if you can hear me, I'm excited to hear your comments on this, that the concern is that financial institutions will not follow the law without a strong federal regulator. In my practice, in addition to addressing enforcement things, is a lot of regulatory work, helping banks and other financial institutions comply with federal and state laws. And state, as we talked about earlier, state AGs and state institutions are really stepping up in this arena and in ways that we haven't seen before. I have on here as the first item that I wanted to mention, just Colorado's DMICA opt-out. State banks are able to export interest rates under DMICA, but states have the right to opt out of DMICA. Iowa's been opted out for a very long time. They've been kind of dormant. They have entered into 3 assurances of discontinuances over the past several years. There are some large state banks that do comply with their interest rate law. Colorado similarly attempted to opt out, and they have defined where a loan is made as being made in Colorado if a resident is physically present in Colorado at the time that they take out a loan. That's not been the view of the industry. The view has been that if the industry is taking actions in a particular jurisdiction, that loan is made in that jurisdiction. Now, again, similarly, I'll say that Iowa has similar language. Again, they've been dormant, so people haven't been as interested. This was just argued before the 10th Circuit. If this goes how Colorado wants it to go, and it was a 3-panel hearing, all of the judges were appointed by Biden or Obama, it didn't seem like it was going to go in a great direction from my listening of that oral argument. But we will see. It could very much upend what state banks are able to do. So again, giving states a lot of power in this area. National bank preemption, I'll mention as well. This again goes to where states are really stepping things up, and financial institutions, like Dan said, our clients really do want to comply. This is a new world for them. They are more concerned about complying with more laws now than I would argue even during the previous CFPB. A lot of things that the CFPB was doing, especially towards the end, states were already active in. As we look at like medical debt reporting, Colorado had passed that law a number of years ago. California passed a law about medical debt that they implemented. So there are things that are already EWA is another one that states were active in before the CFPB started getting active in that space. And then Cantero happened last year. National banks have been able to assert preemption arguments for a very long time. When Dodd-Frank was passed, I, along with others, thought that preemption was going to be scaled back for national banks. Dodd-Frank purported to do that. We did not see that happening. The OCC basically said that everything that previously existed, they're just going to repromulgate, and it was still there. In Cantero, the Supreme Court said, no, there's a more nuanced approach that you need to be looking at how the state laws impact your bank. As a result of this, we have been doing a ton of compliance work for banks, identifying the possible state laws that apply to national bank products and deciding, in some instances, the bank is already complying. In other instances, should it be complying, or are there preemption arguments? One example of this, where this is starting to become active, and there's a number of these things like that. That's where this is an example of private litigation. We've talked about state AGs. There's private litigation. Like there is more compliance. There are more compliance requirements on financial institutions now, I would argue, than there even were when we had a very active federal regulator. So after Cantero, and this happens a lot, there's in the Wisconsin Consumer Act and a number of other state laws, there are notice requirements prior to declaring a debt in default or calling that debt due. State banks do follow these laws today, by and large. National banks, it's split. Some of the national banks take the position that this is preempted. Other banks do follow these provisions. This is one of the first, and there was a previous Wisconsin case prior to Cantero that argued that maybe this was preempted. Now Wisconsin State Court has looked at this post-Cantero, and applying Cantero has said that these Wisconsin state laws, the Wisconsin Consumer Act, apply to national banks. This is huge. Do national banks want to be finding out on a state-by-state basis based on private litigation what laws they should be following? No, they want to know what these are, and they are looking at complying. But where things are with respect to those state laws for national banks and others is really changing. I'm going to, I do have a couple more slides, but in the interest of time, it looks like Ira's back. So I'm going to flip it back to Ira for the last 2 minutes, Dan, unless you want to cover something else.
No, that's great. Ira?
I missed a little bit of it, so I apologize in advance. I go back to when Didmico was first passed, and I remember sort of the arguments we had about opting out of both. It wasn't you could both explicitly opt out or even opt out by action back in the day. I'm glad to see more states opting out of that. I think that's a great step forward. I was present during the preemption wars of the early 2000s of the OCC protecting banks beyond all recognition, and every predatory lending law that we created in the state was preempted by the OCC. So I have very little sympathy. I think those state laws are really important. States have a right to protect their consumers. And if you're going to do business in that state, you should be complying with those states. And we'll be watching very carefully to make sure that financial institutions are, in fact, complying with those state laws until we begin some more preemption wars, which I expect will always happen, because that was a battle that I was in the middle of back in the early 2000s and mid-2000s.
I think you're exactly right. I think that's why financial institutions right now are really focused on this compliance with state law, because of exactly what you're saying, that you're monitoring whether they're complying with these. So the federal regulator could only do so much for so many institutions. Now there's all these state AGs, there are private litigants, like the environment right now for financial institutions and complying with law is at a very extreme level, I think. So yeah, I appreciate that.
I can't say that I'm sympathetic to that, but comply with the law, we won't have a problem. And I think consumer protection law for a long time has not been as strong as it needs to be. And I think the absence of the CFPB will just make people that more hyper vigilant. I think that's the point that we started from here, is that we all realize that the CFPB is not going to be active. The OCC, the FDIC, the FTC are not going to be engaged. So you're going to have a lot of actors across the country looking much more closely at all of this. And I think that's a consequence of what we see, what we've seen happening in the first 2 months of this administration.
Well, and Ira, we can only hope that the plaintiffs that pursue those claims have the same high standards that you have, and we don't continue to see the sadly meritless and other frivolous pursuit of litigation that we see when there's lacking enforcement activity. So
I can only hope that all the financial institutions follow your very careful advice about how they comply, and that they do not take shortcuts in their compliance, because otherwise we'll be looking at them.
Well, of that I am certain, Ira. So thank you. Thank you for your time today, and really grateful for that. Really grateful for Joseph and Jenny and Melanie and Tom and Alan, and just so happy we could pull this together, and grateful for all the folks who were able to join us today.
To make sure you don't miss our future episodes, please subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or wherever you listen. Don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please email us at podcast@ballardspar.com. Stay tuned each Thursday for a new episode. Thank you for listening, and have a good day.